Since its decision in 1954, Brown v. Board of Education has become perhaps the most recognizable case in the history of American jurisprudence. Nearly 60 years after separate but equal became a government-sanctioned policy, Chief Justice Earl Warren's court tore it down. Brown v. Board of Education was actually an amalgamation or combination of several court cases from around the country. Brown v. Board of Education from Kansas, Briggs v. Elliott from South Carolina, Davis v. County School Board of Prince Edward County from Virginia, and Gephardt v. Belton from Delaware. All were appeals from the state district courts, and all dealt with the violation of the 14th Amendment rights of black children in segregated schools. For simplicity's sake, the Supreme Court chose to rule on all cases concurrently. This had the added benefit of making clear the government's position. Segregation isn't acceptable in any state.
Today, education is perhaps the most important function of state and local governments. It is the very foundation of good citizenship. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. In Sweat v. Painter, in finding that a segregated law school could not provide equal educational opportunities, this court relied in large part on those qualities which are incapable of objective measurement, but which make for greatness in a law school. Such considerations apply with added force to children in grade and high schools. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority that may affect their hearts and minds in a way unlikely ever to be undone. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated are, by reason of the segregations complained of, deprived of the equal protection of the laws guaranteed by the 14th Amendment.
Brown v. Board of Education was the case that finally said that separate but equal is inherently unequal. That Plessy v. Ferguson was wrong. They overruled that case, and Brown basically wipes the stigma of separate but equal laws off the face of the legal landscape.
It overturned the system of education in this country, particularly in the South and what we call border states, such as Missouri and Maryland, Kentucky, and so forth.
It's really the case that that put the death knell to Jim Crow segregation as a legal institution.
Those who strategized were looking for a Brown decision that would ultimately say that separate was inherently unequal, that would overturn Plessy, and that would require the integration of blacks and whites in at least the public schools, and then move that concept forward into all aspects of American life to eliminate segregation. That was the goal.
Brown was written as an education case, but very promptly the Supreme Court held that separate swimming pools, separate water fountains, separate golf courses imposed by government were all unconstitutional.
It influences the way Congress several years later passes laws to protect blacks in terms of voting. So it had a ripple effect. I think, in my view, the most important modern case decided by the court.